These underlined terms are the explicitly stated elements of the question, but we think that most of the sub-elements or issues are under the problems and limitations category. We're aiming to analyze the problems and limitations with the new Small Business Restructuring Process, or SBRP for short, with a particular focus on how SBRP simplifies the means to restructure small businesses, maximize survival. We need a more flexible and streamlined insolvency procedure to assist small businesses. Lower costs, higher creditor returns, and company rehabilitation is the goal. The new SBRP, or debtor in possession regime, is one step in this direction towards short time limits, reduced formalities, online innovations, and generally simplified procedures which reduce costs of insolvency. Remember, the MSMEs have needs that are different to large companies, so a separate kind of voluntary administration was needed for some time. It had to reduce costs of external administration by only monitoring directors while they lead a restructuring. But directors must also be reassured that they can act without fear for their various liabilities, for example, insolvent trade. The Small Business Restructuring Process was introduced into the Corporations Act 2001 from 1st of January 2021 through the Corporate Insolvency Reforms Act 2020. It is found in Part 5.3b of the Corporations Act, and it provides a modified mechanism of restructuring for very small insolvent businesses who attempt to survive. To even start talking about the Small Business Restructuring Process, we have to first understand previous formal restructuring procedures. See ASIC's insolvency stats, particularly the highlighted cells. I counted 14 forms of external administration to choose from. But in South Australia, for example, restructuring and restructuring plan had zero uptake. Only one company in South Australia used the new simplified liquidation process in the second quarter of this year. I see no evidence of a tsunami of insolvencies yet across Australia either. In short, since the SBRP came into effect, it's only been used 18 times. With some possible overlaps with other forms of external administration if any restructuring fails. You'll see NA for all years except 2021. It's clear there hasn't been a great demand for SBR. The object of Part 5.3b is shown. We know that the Corporations Act created a uniform legislation administered by ASIC. This part aims only to provide for a restructuring process. Part's objective doesn't aim for recovery or survival like voluntary administration covered by Part 5.3a does. It's merely an attempt. This new insolvency regime or scheme was created to address the anticipated effects of the phasing out of government assistance. Now we will discuss the benefits and drawbacks of the new procedure. I guess the question at the crux of it all is it actually simpler for MSME? Unlike voluntary administration, SBRP is faster, less regulated, is not a one-size-fits-all approach, and directors retain some control over the business. So shouldn't this equate to lower costs? Or perhaps, is it still not low enough? To discuss the simpler process element of the question, you have to first understand how complex previous procedures under voluntary administration were. In fact, voluntary administration is very similar to SBRP. Overall, we see negligible simplification in the law, despite plenty of differences listed in a 2-column table in the explanatory memorandum. But only time will tell whether the different processes in SBRP will change through amendment of the regulation. To discuss the degree of survival, we have to first understand the efficacy of previous methods for MSMEs. As you can imagine, most insolvent companies do not survive, and those that could potentially recover under a modified scheme are barred from the SBRP anyway. We have interpreted simplify to mean everything from lower costs and formalities to accessibility and clarity, while survival is the primary goal which must be achievable for SBRP to have any meaning. I'll now turn to the arguments to be made for and against whether current SBRP achieves the two elements. Some of the SBRP's problems are listed, including that it is still complex and that it may not intervene until it is too late, and so on. In any case, for example, the company is or is likely to become insolvent is a lot more limited than financial difficulties in the UK, which would be a broader term to allow businesses at any degree of risk to use this new scheme. Present slimming down of VA, create SBRP, likely hasn't fully reduced practitioner involvement by a substantial amount. Perhaps greater consultation was necessary if SBRP was to be of more practical use. SBRP's limitations include that it's too narrow in terms of its criteria, and almost all critics touch on how the eligibility criteria limits the uptake, and the liabilities test is too strict, and obviously some other limitations are less of a limitation as much as they are safeguards against wrongdoing, but to me it does appear somewhat limited. Benefits include, well, in theory, it should suit the majority of small businesses, and previous case law can be easily applied here. In terms of division of labor, all three members independently researched and discussed the various pros and cons of SBRP, and at times comparing, at times exploring issues that might not have been found yet, and statutory interpretation as well. Now, regarding the articles, we have several sources which include the Janus faced, which suggests that the law itself is mismatched with the legislator's promises. For example, the text explains that the eligibility threshold effectively excludes desperate businesses from the SBRP, and that the practitioner still has too much power and control, and that the regulations are overused. We'll use this source to cement our view that right from the get-go, there were doubts cast on the effectiveness of SBRP. In terms of the UN CITRO's principles for dealing with MSMEs, they recognize the need for special laws just for MSMEs. And in terms of the chimera of restructuring reform, it contains a strongly supported argument that some key requirements of debtors, creditors, and practitioners haven't been met.